Hello, hello, hello. Okay, you can hear me now. So people should be able to hear me now. Okay. Are we ready to go? So you can hear me now. Okay. Hello, hello, hello. This is Dr. Olu Asekun here. Welcome to our live podcast. Yes, today is another Wednesday. Remember to join us every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific Time. And that is 6 p.m. Nigerian time. So remember to join us every Wednesday. Remember to subscribe to our channel so that whenever we go live, you can be notified. Remember to invite family and friends because this is a very useful information that we are providing every week. And I believe that it will be useful to a lot of people. So even if you are a US citizen, it doesn't stop you from participating in this podcast. It doesn't prevent you from listening to this podcast because you never know where the information you are receiving will be very, very useful. So you are welcome again to our podcast. Today, I'll be discussing overstay as one of the grounds of inadmissibility. We are discussing inadmissibility series. So overstay is something that we'll be discussing as one of the grounds of inadmissibility. This is a very, very common topic. It's a kind of question that we get every time. People come in with visiting visa and they overstay. It's a question we get all the time. So, how does overstay impact one's ability to be legalized in the US, one's ability to get green card in the US? How does overstay impact it? That is the topic we are discussing today. So, while I do the preliminary analysis, start sending in your question. As I said, question bordering on overstay. So, if you have overstayed, or if you know somebody who have overstayed, or you have any question relating to overstay, you can start sending in the questions now. Okay. When we are talking about overstay, we are talking of overstaying the I-94. I deliberately did not call this topic visa overstay because I know that it will be confusing to a lot of people if we use that word visa overstay. So I just use the word overstay because there is a difference between visa and I-94. And I've stated in previous episode, visa, the validity of a visa does not have anything to do with the legal status here in the United States. Visa is only relevant when somebody is outside the US. When you are inside the US, visa is not relevant. So it is possible for somebody to have a visa that is expired and the person is still legal here in the US. They are two separate things, and I don't want confusion. Now, whenever anyone come into the US, you are given I-94. You are given I-94. Even if you are not given the physical I-94, because now it is electronic. Even if you are not given the physical I-94, even if your passport is not stamped, there are other ways to retrieve your I-94. You could retrieve your I-94 on CBP website, Custom and Border Protection. They are the one that admit people into the United States. So you should be able to retrieve your I-94 on their portal, CBP portal. Now, if you come in and they give you 6 months, it doesn't matter how long your visa is. Even if your visa is 5 years, at the end of the 6 months, you will be out of status. you will be considered overstay, even if you still have 5 years or 2 years valid visa. At the end of the 6 months given to you at the port of entry, you become an overstay, and your visa may not be relevant because visas are not relevant in the US. So you become an overstay already. Now, what is the impact of overstay? When you overstay your I-94, if CBP gives you 6 months at the port of entry and you overstay the 6 months, it has some legal implications on your ability to get green card. One, if you overstay your I-94, you will no longer be able to do what we call change of status. You will no longer be able to change your status. The moment you overstay your I-94, you will no longer be able to do change of status. Now, change of status is different from adjustment of status. So right now, I'm addressing change of status. You will not be able to change your status. Normally, when somebody enters the US with a visiting visa or with a kind of non-immigrant visa means that the kind of status that is temporary, something that is temporary. Maybe you are coming here temporarily to visit, or maybe visitor for pleasure as a tourist, or maybe visitor for business. You are coming to discuss business, or you even come in with a temporary working permit, temporary visas like H-1B visa, L visa, O visa, P visa, all R visa, all kinds of visas that enable you to work on temporary basis. You will no longer be able to do a change of status from one immigration status to another if you overstay your I-94. So in other words, let's say you come in with a visiting visa. You, at the port of entry, you are given 6 months. At the end of the 6 months, you will no longer be able to change your status. You can no longer change from visitor to student, for example. You can no longer change from visitor to religious worker, for example. You can no longer change from visitor to maybe H-1B, for example. You will no longer be able to. How does overstay impact immigrant status, which is a green card? Now, if you overstay your visa, if you overstay your I-94, if they give you 6 months at the port of entry and you overstay the 6 months, you will no longer be able to adjust your status to a permanent resident on employment basis. You will no longer be able to do that on employment basis. So in other words, if you overstay your visa, let's say you come in on a student visa and you go to school, you graduated, and you become overstay. You didn't change your status while you are still in status and you become overstay. Or let's say you come in with visiting visa. They gave you 6 months and the 6 months expired. After that expiration, you will no longer be able to apply for green card based on employment. So even if you become a registered nurse or you find an employer that is willing to petition for you, you will no longer be able to get green card because you have overstayed your I-94. So that is the implication. The only exception to adjustment of status when you overstay. Now, let me explain this further. I stated at the beginning that overstay, a change of status is different from adjustment of status. So when you change your status, that is when you are changing from one non-immigrant status to another non-immigrant status. When you adjust your status, that is when you come in on a temporary basis and you are applying for green card. So they are two different things. So overstay prevents change of status. There is no exception to it. Once you overstay, you cannot change your status. There is no exception. Now, when you overstay, It prevents adjustment of status for who marry a legal permanent resident. There is a difference. One of the differences is that for somebody who married a permanent resident, if you overstay, you will still not be able to adjust your status. It's just going to have the same effect as somebody who is trying to change status. Somebody whose I-94 expires and then married a permanent resident, a green card holder, you will still not be able to get green card because of your overstay. So it's still going to be a ground of inadmissibility. You will not be able to get your green card because you have overstayed. The exception, the family exception, does not extend to green card holder. The exception is limited to U.S. citizens only. So that is one of the major differences between somebody who is married to a U.S. citizen and somebody who is married to a legal permanent resident. So overstay can have devastating effects, and that is why we are treating it as a topic. Now, let me go further to one of the major effects of overstay, because we see this all the time. If you come into the US and let's say you come into the US on a temporary basis, on a visiting visa, for example, and they gave you 6 months at the port of entry, and the 6 months expired and you are still here, you overstay. Depending on how long you overstay, if you have a valid visa and you step out of the US, you may not be able to re-enter the US. Now, the timeline of the ban depends on how long you overstay. It also depends on some other circumstances which I'm going to explain now. Now, let's say you have a 5-year visa. You enter the US. At the port of entry, they gave you 6 months. You stay here 6 months and 2 weeks. If you step out of the US, even though you have a valid visa, if you attempt to come back, you will be at the mercy of CBP officers. Even though you only overstay for 2 weeks, you could be denied admission. It is not 100% certain that you will be denied admission, but you could be denied admission because at that stage, within the first 180 days, it becomes discretionary. CBP officer can allow you in and they may choose not to allow you in if you come back. So it becomes a discretionary factor. Now, if your visa expires and you want to renew it, the embassy will realize that the consular officer will realize that you overstay for 2 weeks. The officer may choose not to renew your visa because at that stage, it is a discretionary matter. Any period of overstay that is less than 180 days, that is less than 180 days is 6 months. Any period of overstay that is less than 6 months gives the consular officer or the CBP officer the discretion whether to renew your visa or not, or whether to admit you into the US or not. It is a discretionary matter. Now, if you overstay for 6 months or more, but less than 1 year, if you overstay for 6 months or more, but less than 1 year, if you step out of the US, you are inadmissible to the US for 3 years. That is statutory. That is not discretionary. That is statutory. You cannot come back to the US for 3 years. So even if you have a valid visa for 5 years, if you overstay for 6 months or above, but less than 1 year, if you attempt to re-enter the US, you will not be admitted into the US for at least for the next 3 years. That is statutory. It is not discretionary. If, on the other hand, your visa has expired and you try to renew your visa, you will be denied visa. They cannot renew your visa for 3 years. That is statutory. It is not discretionary. So you will be banned for 3 years. Now, if you overstay for 1 year or above and you step out of the US, if you attempt to come in, even with a valid visa, you will be barred from entering the US for a period of 10 years. This is not discretionary, it is statutory. If your visa expired and you want to renew it, you will be barred for 10 years. You will not be able to come back for 10 years. It is statutory, it is not discretionary. Now, let me explain this ground of inadmissibility. Even if you are married to a US citizen, it still does not prevent you from being barred for 10 years. You will still be barred for 10 years because, as I said, it is statutory. This is not one of those discretionary items. So it doesn't, but you may be able to apply for a waiver of grounds of inadmissibility. I know that in some of our podcasts, we have explained all the different ways, explained a topic on non-immigrant waiver. So if you are in this situation and you want to find out about waivers, you can go to our channel, on our YouTube channel, and look for the video on waivers. So we have discussed waivers extensively, immigrant waivers and non-immigrant waiver. But because we are discussing grounds of inadmissibility today, overstay to be precise, we will not go into the issue of waivers. But we have videos of previous podcasts where waivers are discussed. So for some people, you may be eligible for a waiver. Some people, there are no waivers, especially if the applicant is the mother of a petitioner, where the applicant is the parent of a petitioner. No waiver is available. There is no waiver at all. There's no waiver at all. But of course, every situation is different. I've always said, and I will repeat again, immigration is not a one-cap-fits-all. The fact that somebody tried something and it didn't work does not mean that it will not work for the next person. So if you find yourself in this position, you might want to consult with an experienced immigration attorney because every case is different. Even though statutorily you may not be eligible, there may be some loopholes, there may be things that may be workable in your situation. So this is not a one cap fits all, but it's a general statement. So the general rule is that if you overstay for 1 year and above and you step out of the country, if your child is the one filing a petition on your behalf, there is no waiver for you. You are barred for a period of 10 years. If, on the other hand, your spouse is the one filing a petition on your behalf, you may be eligible for a waiver. So every case is different. So you might want to consult with an experienced immigration attorney to determine, if you find yourself in that situation, to determine whether a waiver is available for you or not. But we are discussing inadmissibility today. One of the grounds of inadmissibility is overstay. I can see that questions have started coming in, so let me go into answering the questions as we proceed. The first question: will I be eligible for forgiveness if I have overstayed due to circumstances beyond your days? After the expiration of your I-94, that gives the CBP officer or the consulate officer discretionary authority to either renew your visa or to grant you admission. So if your overstay is less than 180 days, yes, that is where the issue of explanation can come in. That is where discretion can come in. That is where you can explain that, oh, the reason I overstayed was because of COVID. I wanted to travel, but there was a travel ban at the period. I couldn't get airline to take me to my home country. This is where you could give explanation. But where your overstay is 180 days and above, then you are subject to 3-year ban. That is statutory. No explanation can change a statute except the law is changed. So those ones are statutory. But if it is still within the initial 180 days, if the overstay is within the COVID, even if uh, uh, the airlines are shut down, even if the airports are shut down, people are not allowed to travel in or out of the country, that still does not create a justification for overstay, because there is a room for you to apply for an extension of your stay. So if you have the opportunity to apply for an extension of your stay and you fail to do so, you cannot blame COVID for that. COVID may not be a justifiable reason, because COVID did not prevent you from applying for an extension of your stay. If you are given 6 months at the port of entry and then COVID struck and you realize that you will no longer be able to travel within that 6 months, there is provision for you to apply for an extension of your I-94, to apply for another 6-month extension. So if you apply for that, you will be maintaining legal status. There will not be question of overstay. But if you fail to take that step, you cannot blame it on COVID. You can only blame it on ignorance, which of course is not an excuse in law. The next question: how does the government know I overstay my visa? Well, this is too elementary. This is too preliminary. Everybody coming into the US is admitted, except if you enter without a inspection, which of course that is even completely illegal. So the question of overstay does not even, there's a difference between somebody who overstay and somebody who entered illegally. So for the purpose of this discussion today, we are not talking about people who entered the US illegally. We are talking about people who overstay. That is what we are addressing today. So if the government gave you 6 months at the port of entry, they have your record. So when the 6 months expires and you don't leave, it shows in the record that you are still here, because every airline that travel internationally, their system is connected with the CBP. So when you go to the airport and you try to check in, you give them your passport, you try to check in to travel, that system is connected with the CBP system. So if you leave the US today, for as long as, except if you go out through the border, walk out of the border, that is BP, and they will know that you left on a particular day. So yes, they will have the record. That is why if you want to know if you are here legally, or even if you have overstayed, if you want to know whether they have your record or not, go to CBP portal and put your information. Use your passport information. It will ask you for your name, your first name, last name, date of birth, your passport number, and the country that issued your passport. It will give you your travel history. So you will know, they will have the record. So if you didn't leave, your record will only show the date you entered. It will not show the date you departed. So the record, they can always know. Next question: who qualify for a waiver of inadmissibility? Yeah, I think I've also explained that. If you are subject to 3 and 10-year bar, it depends on who your petitioner is. If you have a petition filed on your behalf, if that petition is filed by your spouse, you may be eligible for a waiver. But if that petition is filed by your child, you are not eligible for a waiver. So if the petition is filed by your parents, you will be eligible for a waiver. So in other words, a waiver in this circumstance may be eligible for people whose petitioners are the spouse or parent, but waiver is not available for somebody whose petitioner is the child. I believe that the Congress intentionally put this in the statute so as to discourage parents from bringing their children illegally into the U.S. So that is why if those children eventually become a U.S. citizen or those children were born here, they made it difficult or impossible for those children to petition for the parent who carried out those illegal activities. I believe that was intentional. It wasn't by accident. So if your petitioner is a spouse, you may be eligible for a waiver. If your petitioner is a parent, you may be eligible for a waiver. But if the petitioner is a child, you are not eligible for a waiver. Next question. Exception is only available while that child is under 18 years old. The moment that child turns 18, the exception is no longer available. So the exception that is available for a child is only valid while the child is under 18. But the moment the child turns 18, the exception goes away. Next question. I was here on F1 visa. My I-94 does not have an expiration date. It only says DS. Yes. How do I know when it expires? Well, for those who are here on F1 status does not expire. The DS simply means duration of stay. So, if you are here as a student and you keep going to school, maybe you started from a bachelor's degree, you completed your bachelor's, you go for your master's, you completed your master's, you decided to go for PhD. For as long as you are in school, it doesn't expire. And it is because the government cannot predict when you will complete your studies. That is why they cannot put a timeline on it. That is why they intentionally leave it as duration of studies. So it doesn't expire for as long as you are in school. You are not an overstay for as long as you are in school. However, there are other machineries that are put in place that enables the government to know when somebody overstays. There are other machineries that are put in place that enables the government to know when a student fails to go to school, when a student fails to register for class, or when a student fails to take the minimum number of required credit hours. So there are a lot of things that can kick you out of status, even though your I-94 states duration of status. When somebody works illegally, you can be out of status, even though you are on F1. So there are so many things that can kick you out of status. But again, DS simply means duration of status. Next question. Is overstaying a violation of non-immigrant status? Oh, yes. Oh, yes. If you are given a visa and you come into the US and you are given a specific month to stay, if you overstay that month, that is a violation of your non-immigrant status. Yes, it is overstay. Overstaying is a violation of non-immigrant status. Yes. Next question. Is overstaying a visa considered criminal? No, it is not a criminal matter. Overstaying is not a criminal matter, but it is an immigration violation. So if you overstay your visa, that is not a criminal matter, but it is an immigration violation. Immigration violation is different from a criminal violation. So overstaying your visa is not a criminal matter, but overstaying your visa is an immigration violation. Who has the burden of proof in inadmissibility? Well, everyone that is applying for benefit, whenever you apply for anything, whether you want to change, you apply for a change of status, whether you apply for adjustment of status, whether you apply for a green card, whatever you apply for, every time you apply for something, you have the burden to prove eligibility. The burden is on you that to show that you are eligible for what you are applying for. So whenever you apply for something, you have the burden of proof. Can I enter US after 10-year ban? Do I just apply for a new visa? What's the procedure? Yes, if you are subject to 10-year bar, you wait the 10 years outside the US. So at the end of the 10 years, the bar will fall out. So you will now apply afresh for a visa. But the truth of the matter is that even though you have already served the 10-year ban, the consular officer can still consider it in exercising discretion whether to give you visa or not, especially non-immigrant visa. They can still consider it. So even though you have already served the ban, you can still be denied non-immigrant visa. But it is different for an immigrant visa. Next question. How do I know if I'm inadmissible to the USA? You will know if you have done any of the acts of inadmissibility. If you have entered the US before and you are given 6 months to stay here and you stay for more than 6 months, you already know that you violated the law. You know that you overstay. If you are inadmissible based on criminal ground, when you are convicted of a crime, you will know that you have an issue with a criminal conviction. When you have other grounds of inadmissibility, maybe on health ground, if you apply for an immigrant visa and you did your medical examination and the report shows that you have one of the inadmissible ailment, maybe hepatitis B or something, you will know. I mean, the doctor who tested you will still give you your own copy of your medical examination report. So you will know. Definitely you will know. Next question. What grounds of inadmissibility cannot be waived? Well, there are some grounds of inadmissibility that cannot be waived. For example, somebody who is convicted of aggravated felony, that kind of ground may not be waived. Because even if you already have the green card, they will still take it away from you. So applying for a waiver may not be successful. Secondly, if you enter the US illegally or you overstay your presence in the US for a period of 1 year or more, and then you enter the US and you leave the US and you re-entered the US illegally, that is a permanent bar. So there is no waiver for that category because that will constitute a permanent bar. So you may not be able you may not be eligible for a waiver. And again, if your qualifying relative is your child, especially adult child, you may not be able to get the waiver. So yes, there are some people who are not eligible for waiver. I'm trying to determine the next question. As a US citizen, it is my duty to report an overstayed visa to the U. Oh, is it my duty to report an overstayed visa to the USA? I don't think so. I don't think the statute, or I don't think there is any law that imposes that duty on anyone. It is a matter of personal conviction. If you report somebody who overstay to the authorities, yes, they will take your information. But are you mandated to report? No, you are not. It is something that is completely optional to you. So you can choose to report somebody and you can choose not to. So there is no obligation to report. The next question. What is my immigration status if I overstay my visa? You don't have status. You are illegal. If you overstay your visa, you become illegal. So there's no status for you if you overstay your visa. You become an illegal alien, unlawful alien. Will I be deported if I overstay? Well, that depends on the policy of the government. So the law is that if you overstay, you are supposed to be removed. That is the law. Now, how this law is enforced varies from administration to administration. And we just saw that recently with President Donald Trump administration. They were very, very hard on enforcement. So during President Trump administration, you don't have to do anything. If you overstay, they can come get you in your apartment. They can come get you in your brother's house. They can come looking for you in whatever address you provided when you are applying for visa that you are going to stay. So it varies from administration to administration. So enforcement is something that is discretionary. And it is the same all over the world. Because even in criminal cases, the prosecutors, they have what is called prosecutorial discretion. They can look at a criminal and say, you know what, we don't want to spend a lot of time on pursuing this type of case. Let this one go. And even in some African countries, they call it nolle prosecute. It means that, okay, we have looked at this, we don't want to prosecute this person. So it varies. So it depends on what the policy of the administration is at a particular time. The next question, can I fly within the US if I have overstayed? Is there a risk of getting caught? Yes, I will tell you there is a risk, but it depends on where you go. Every city in the US, every state, they have different policies. Like I said, certain things are discretionary. Some people may see someone who overstay and report them to authorities. Some people may see someone who overstay and ignore it and not have anything to do with it. So it depends on where you are going. But one thing I will tell you, if you fly near a city that is close to the border, your risk will be very, very high. For example, I do know, I have the personal experience that from El Paso International Airport, if you fly from that airport and you are illegal, you may be at risk because in that airport, even while going through security, there are CBP officers there that are specifically checking people's status. That is because El Paso is a border city. People can walk in illegally through the border and then attempt to fly from the plane, maybe to another state, to a different city, just walk across the border, is not trying to go into the hinterland. So if you are in unlawful status and you want to travel, make sure you do not go near cities that are border town. The next question. If I overstay my visa, if I overstay my I-94 one day, but my visa was still valid, is my visa voided? No, 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 no. Your visa has nothing to do with your I-94. And that is why we separated it at the beginning of this podcast. Visa is completely different from I-94. So if you overstay your visa, if you overstay your I-94 and your visa is still current, no, your visa is not voided. You can still use your visa. However, remember my explanation. If your visa expires, you will need to go back to the US Embassy to renew it. The embassy will see that you overstay by one day. If your visa is still valid, you can just jump into an airplane, buy a ticket, jump into an airplane, and come to the US. Your visa is still valid. But at the port of entry, the CBP officer will see that the last time you were here, you overstayed by one day. So the officer has the discretion to either allow you in or to deny you entry. The officer may ask you questions. They may take you to secondary inspection and ask additional questions. Okay, the last time you were here, you told us you are coming here for 4 weeks, but we see that you are here for 6 months and one day. What were you doing? How did you take care of yourself? Did you work illegally? So they can take you through secondary inspection. At the end of the day, they have the discretionary authority. For as long as your overstay is less than 180 days, they have the discretionary authority either to allow you in or to prevent you from coming in. So they have that discretion, but it doesn't affect your visa because the visa is only useful with the airline. So the airline is not going to have your overstay record. So they will still carry you. They will bring you in. It is only the CBP officer that will see your overstay and then determine whether to waive it or not, whether to allow you in or not. But your visa is not voided. Next question. Can my family join me in the US if I'm on F1 visa? What are the requirements to make the applications approved? Well, if you are on F1 visa and your family is outside the US, they will need to apply for F2 visa. F2 is the dependent of F1. So if you are already here and you are on F1, your family can apply for F2 visa at the airport. The only thing they will need to show is that, one, they will show evidence that you are still in school. If you are on F1 and your family is applying for F2, make sure you obtain and send them your transcript to show that you are actually taking classes, you are in school, you have not overstayed your status. And if possible, get a letter from your school confirming that you are still in school. And of course, you also have to obtain F2 I-20 for your family. So your school will be involved because they have to issue an I-20 asking the embassy to give your family F2 visa. So the I-20 will indicate that you are still here in school and you are not violating your status. In addition to that, the embassy will want to see proof of your financial ability, because if you are here, you are in school, and F1 status does not permit you to undertake full-time employment. When you are on F1, you can only work a maximum of 20 hours per week on campus. So The embassy may want to see evidence of how you are going to sustain your family. So if you are bringing in your family, you have to show that you have the financial capacity to take care of them so that when they get here, they will not become a public liability. So those are the things that you need to show, and then your family can apply for F2 visa. Having said that, I still want you to know that F2 visa, just like every non-immigrant visa, they are discretionary. You can still provide all of these things and the embassy may choose to deny them visa. Every single non-immigrant status is discretionary. So I want you to have that at the back of your mind. But you still have to play your part by providing the necessary documentation, evidence that you are still in school by way of your transcript, new I-20 for F2 for your family, and then evidence that you can afford to take care of your family, financial evidence that you can afford to take care of them and all of that. So that will be necessary. Next question. Can I be deported at the airport if while trying to travel within the US they determine that I have overstayed? No, you cannot be deported at the airport. That is not the way it works. So if they catch you, or if you are caught at the airport that you overstay, they will only hand you over to CBP, Customs and Border Protection. You see, the Department of Homeland Security, they have multiple agencies under it. Under the Department of Homeland Security, we have USCIS. Those are the ones that process applications. Under the Department of Homeland Security, you have CBP, Custom and Border Protection. Those are the ones that admit people into the US. And then the same Department of Homeland Security, you have ICE, Immigration and Customs Enforcement. So those are the ones that deal with people to be deported. Now, if you are caught at the airport authorities will hand you over to ICE, that is Immigration and Customs Enforcement. So they are the one that will now process you. ICE is not just going to buy the next available ticket for you and put you in the plane. No, that is not the way it works. You are already here, so you are entitled to all the due processes of law. So ICE will take you into custody. They will process you. Process you means that they will take all of your information, take your fingerprinting, they will issue a document called notice to appear, and then they will make what is called custody determination. Custody determination is that, okay, are we going to allow this person to be released on bond or to be released on self-recognition, or are we going to detain this person? Now, under this current administration, this Biden administration, they will not detain you, but they will take you into custody, process you, take your fingerprinting, issue NTA, do all of that, and then release you either on self-recognition or on bond. Now, when that notice to appear is filed with the immigration court will now send you a notice to notice of hearing for you to appear at the immigration court to come and explain why you should not be removed from the US. So when you appear in court, either with a lawyer or without a lawyer, the judge will ask you if you have received the notice to appear. Once you confirm it, the judge will ask you, how do you plead to the allegations in the notice? It is the notice to appear that will accuse you of overstaying. The notice to appear will explain why you are charged to court, that you are admitted to the US on so day, that you overstay your admission, and that on that basis you are eligible to be removed from the US. So the judge will ask you how you want to plead to the allegation and whether or not you have a relief. So the fact that they arrested you at the airport does not mean they are deporting you. No. You may even get to court and then get your green card even from the court, depending on your peculiar situation. So If you go through some of our previous podcasts, we have discussed some of the defenses available to people when they are in removal proceedings. So taking you through removal proceedings by itself does not mean you are going to be deported. Next question. If I invited my family member to the US for my graduation and they overstay, can I get into trouble? No, you cannot get into trouble because you don't have control over what people do. You can only get into trouble if the family member is a minor and you have control over him or her. That will be your responsibility. But if the family member is an adult, you can tell them to leave and they may tell you they don't want to leave. There is nothing you can do. You are not a police officer. You cannot force them to leave. So there is nothing you can do. You can only tell them that, oh, I will advise you to go and not overstay. If they choose to stay, there is nothing you can do. So, no, you can't get into trouble for that. Next question. Does TSA have authority to ask for immigration status? No, they do not. Line. Their own is to ensure that you are not entering the airplane with dangerous material or something that you can use to harm somebody. You are not entering the plane with things that are contraband. You are not entering the plane with explosive items and things like that. So TSA's duty is to secure the airline, to secure the airport and the airline. Their duty does not extend to immigration. It is none of their business. Do I have the right to retain an attorney before answering the officer's question if I was taken for a second inspection at the airport? Well, remember, this is a very technical question. When you are coming into the US, until you are admitted, you are not in the US. So, if you are not in the US, you may not have access to all the benefits of people who are in the US. For example, the question about somebody who overstay and is traveling inside the US and all of that, that person is already in the US. So when the person is arrested, he or she is entitled to all the due process of law. But if you are coming from outside and you have not been admitted, technically you are still in your home country. So you do not have access, you do not have right to all these benefits. So if you ask for a lawyer, if they are magnanimous enough, they may oblige you. But if they choose not to, there is nothing you can do because you don't have that right yet. You are not in the US yet. You are still technically standing in your home country until you are admitted. But at that point, you have some right. For example, if at that point you choose to apply for asylum, the officer has an obligation to give you asylum application and to take you that process. The moment you say, oh, I'm scared of going back or I will be killed if I go back, there's a mandatory obligation to protect you and give you an application for asylum. The next question. If I transfer from a 4 years master to a 2-year college, mandatory, they are discretionary type of application. So a consular officer may think about it. Oh, this person already have a master's degree or this person already have a bachelor's degree. Why go back to a 2-year college? This may just be a desperate attempt to stay in the US. Yes, they may consider it to deny them visa, but they may consider it and also still give them visa. But it is a discretionary factor. Yes. I mean, ask yourself, if you are the officer and somebody who already has a bachelor's degree is getting admission to go into a 2-year program, So you'll be wondering what exactly is going on here. This person is just desperate to stay in the US. It will be a consideration. However, that doesn't mean they will be denied, because they can bring it up and you can still justify it. For example, maybe you were a teacher before and you choose to change profession. You decided to go into nursing. The fact that you have a degree before does not mean you'll be admitted into nursing. You still have to go back to start nursing from the scratch. So you may go back to 2-year college to do that. You may have studied history before, and now maybe you want to study English or you want to study computer science. Your degree is not going to convert into computer, so you may need to start from the scratch and learn computer science from the community college. So you may justify it, but the question is, will it be a consideration? Yes, it could be a consideration. The next question. I did not know I had overstayed my I-94. I did not know the difference between I-94 and visa. Is there anything I can do to make my re-entry easier when I come back into the US? Well, it depends on how long you overstay. As I explained, if your overstay is under 180 days, all you need to do is to prepare for an explanation when that question comes up at the embassy when you are trying to renew your visa. Because the issue is, whether you know or you didn't know, the question is, when you obtain your visa the first time, what did you tell them you are coming here to do? How long did you tell them you are coming here to stay? Because you may not even overstay your visa and you can still be denied. Because if you told them you are coming in for a 2 weeks vacation, maybe 2 weeks tourism, and then you came here, you spent 5 months. If you go back to renew your visa, they can still bring it up. Oh, the last time you went to the US, you told us you are going for 2 weeks vacation. We noticed that you were there for 5 months. How did you maintain yourself? What about the job you are doing at your home country? Did you resign? Because you can't tell anybody, you can't justify how you went away for 5 months from your job. So what did you tell them? Nobody gets 5 months leave. Nobody gets 5 months annual leave. So what happened? You told us you are going for 2 weeks holiday. How did that translate to 5 months? What were you doing? Where did you stay? How did you take care of yourself? What about your job at home? Was your job secured? Why would an employer allow you to go for vacation for 5 months? Those are all legitimate questions that can come up. So you have to be prepared for them. You have to so it doesn't matter whether you really know that you overstay or not. It is more like, what is the motive? What were you doing for 5 months? I've seen situations where somebody came in with a visiting visa, was given 6 months at the port of entry. He went around the US, spent a total of 5 months, didn't overstay, and went back home. Spent about 3 or 4 months at home and wanted to come back the second time. So he got to the port of entry. So they stopped him. They look at his record. The last time you came, you told us you are coming here for 3 weeks. But we realized that you are here for 5 months. What were you doing? So they took him for secondary inspection. They started asking questions. How did he survive? Unfortunately for him, of course, out of ignorance, he informed them that, oh, he was a minister. So he was ministering in different churches. And they asked him, how did you survive? He said, oh, they were paying him honorarium. Then the officer asked him, do you know that that was a violation? Your visiting visa does not allow you to work. It means that while you are here, you are working without authorization. That was a violation of your visiting visa. So they denied him entry. So you don't necessarily have to overstay for 6 months before you are denied admission. So you still have to justify whatever you did. The fact that you told them you are coming for 3 weeks and you ended spending 5 months, that in itself is a red flag. It's going to raise a lot of issues. It's going to raise questions. It's going to alert the officers to your presence here in the US. So I believe that was probably the last question for today. It's already 1:08. I'm not complaining because we started a little bit late. So if there are no other questions, we will be rounding up today. We will see you again next week, Wednesday. Remember to call family and friends. Remember to invite them to join us. As you can see, this is a free information. Even after this podcast, the video will be there on our YouTube channel for weeks, months, years. So it's a very valuable tool. So the only way to show appreciation is to invite other people to benefit from it. And as I stated, you don't have to be in a position of somebody looking for visa, somebody looking for somebody trying to prevent overstay. You could even be a US citizen. You never know where the information you are receiving today will be useful. You never know. But one day, that information may be useful. That is why we implore you to pass it across, pass it around, let others too benefit, let others know that this information is available. So we are doing this as our own way of contributing our quota to the prevention of illegality, to help our people, to help foreigners to navigate this country. That is the only reason we are doing this. The only way to show appreciation is to invite your family and friends. Let them all subscribe to our channel so that whenever we go live, you will be notified. I will stop here for today. We hope to see you next week. I believe that next week we will continue the inadmissibility series. So, hope to see you next week. Have a wonderful week ahead.